Good morning.
Good morning.
My name is, I'm sorry. The Committee for Parole is called to order. Today's date is October 23rd, 2025. The time is 8:53. My name is Chuck Tillis, and I'll be chairing this committee today. My colleagues are Ms. Jerry Ledoux and Mr. Steve Prater. Would you state your name and, I'm sorry, we're located at the DOC office here in Baton Rouge. Staff, would you identify yourself for the record? Jen Cavalier.
Parole Williams.
Okay. Our remote location today is at CALCASIEU Correction Center. Would you state your name and DOC number for the record, please? Can you hear us?
Can you hear me?
Okay. Would you state your name and DOC number for the record, please?
I'm the brother of the person that's incarcerated. Y'all's 225-200-2529 keeps calling me. Is that y'all?
Yeah.
Okay.
Hold on, here. We're gonna get it straightened out.
Okay, I'm gonna answer this phone call.
Good morning. The Committee on Parole is called to order. Today's date is 10/23/2025. My name is Chuck Tillis. My colleagues are Mr. Jerry Ledoux, Ms. Jerry Ledoux, and Mr. Steve Prater. We're at the DOC headquarters here in Baton Rouge, Louisiana. Staff, introduce yourself.
Jasmine Thompson.
Devin Cavalier.
Parole Williams.
Okay, our remote locations at the CALCASIEU Correctional Center. Would you state your name and DOC number for the record, please?
Kyle Joseph Natali, DOC number 632078.
Okay, and I see you're represented with your attorneys.
Yes, sir. Adam Johnson, borrow number 32515, and Mr. Fred LeBlue is here with me.
28654 is my borrow number.
Okay, thank you so much. Ms. Ledoux will be handling your case today, and she's going to ask some questions, and then I guess she will get with the attorneys to get their information from them.
Yes,
okay.
Thank you, Mr. Chair. Good morning, Mr. Natali. I'll start off by saying that I have received in our packet the letter from Adam Johnson regarding the recent court hearings that you've had on this matter. And I will still ask you, I'm going to read the allegation against you, and I'm still going to ask you for a plea, and you can decide how you want to answer that. Guilty, guilty with a statement, or not guilty. It's alleged that on 1/19/2025, you engaged in new criminal conduct and were consequently arrested by Lake Charles Police Department for operating a vehicle while intoxicated, fourth offense felony, and obstruction of justice, a misdemeanor. The pending charge had been set initially for 10/8/2025, and it is still continuing. How do you plead on that?
Plead not guilty.
Mr. Natali, were you arrested on 1/19/2025?
Yes, ma'am.
Okay. It's my understanding at that time you refused field sobriety test. Is that correct?
No, ma'am.
No, ma'am. That's not correct.
Okay. I do have logged into the evidence in our file the results of a blood alcohol draw. At this time, I will allow Mr. Ryan Natali, your brother, to make a statement on your behalf.
How's everybody doing?
Fine.
I'm just gonna speak on behalf of Kyle. As I said in my letter previously, we grew up in a household and became split at a young age. I kind of sided with my mom. We're 7 years apart. So he's 7 years older. He sided more with my dad, who was, physically, mentally, financially abusive, was, on substances, alcoholic, all the things. He left home when I was 2. He moved to Lake Charles while we lived in Lafayette. My brother kind of went with him, kind of was his mentor in obviously a negative way. I sided with my mom. I mean, she never was in any trouble. She just was, a regular person. Through that time, he visited home a lot. My brother's my best friend in the best way. He's smart. He does everything I know today is really on him. I wouldn't probably be where I'm at if it wasn't for him. He has, outside of any trouble, he's the best guy. Everybody, for where he works. I think he's been incarcerated for, I think it is almost 11 months, and I think he's almost still kind of guaranteed his job. His boss texts me once a month asking about an update on him. He's well liked. He's a great brother, great son. Everybody, he has a huge support system. He's the best person you can ask for, really. Just, one of those things that a little help wouldn't hurt. Treatment and everything. He'd be the best person that you can ask for.
Thank you, Ryan. I did read your letter. I appreciate you being with us today.
Thank you.
I think at this point, if the attorneys, Mr. Adams and Mr. LeBlue would like to make a statement to the panel, this would be an appropriate time.
Sure, I appreciate it. You can hear me okay?
Yes.
Okay, I'd just like to thank the board for its time and service to Louisiana. I know that this is a tough job, but we certainly appreciate the opportunity to be heard. Ms. Ledoux, it's certainly, I hope, an advantage that we have someone with your experience, and we have the rest of the board members who obviously are very, very experienced and have been working in this area for a while. We are requesting deferment, just as we requested deferment at the preliminary hearing. When we appeared at the preliminary hearing, Mr. LeBlue appeared on my behalf and requested that we continue the matter because I was in federal court, could not be there, had been summoned to federal court. That was denied, and we were told by Mr. Vidrine that that a new law had been put in place and that deferment couldn't be requested. We did recently run into Mr. Vidrine, and he informed us. He said, "Look, I think that was actually an error." So to his credit, I think he's corrected himself. But we are requesting deferment. If not allowed to defer, we are requesting that the board recess after the hearing, allow the record to be remained open for us to submit some additional documentation that we just recently received, and reserve ruling until the disposition of the pending criminal charge. I believe this is allowed. Either of these options are allowed under board policy 11-1115. Again, I appreciate the opportunity to be heard. Mr. Natali's case is complex in as much as he has 3 different matters pending, but I'm sure that you've all seen this before. I'd like to explain a little bit. We have the parole revocation, which we're here for today. We have a pending probation revocation hearing that's been deferred. And we have a new criminal charge. And all of these instances are based in part on the allegations of the new criminal conduct, namely his being arrested as Ms. Ledoux described for a DWI, a 4th offense in Lake Charles on January 19th. In terms of the proceedings that we've had thus far, we've had a hearing on the revocation of probation on July 16th. At that revocation hearing, there were several pretrial motions, and I would have considered that kind of like a mini trial. There was a motion to suppress heard, a motion to quash heard, which resulted in the judge hearing from the arresting officer, from the lab technician. And the judge, the same judge who sentenced my client on the previous case for which he is now on parole, that judge deferred ruling on the probation revocation, and he suppressed all evidence in the case for a variety of reasons, including the improper handling of evidence, no probable cause for the arrest, intentional misrepresentations in the search warrant, among others. Kyle's case is extremely unique in that the video evidence and testimonies shows that prior to being stopped, the police officer's dash cam shows no bad driving at all. And he is immediately arrested despite his cooperation, essentially because it was cold outside that day.
He did offer to.
And at the scene, thank you, at the scene, when asked if he would do standardized field sobriety tests, he specifically stated he would and was willing to do same. Despite that, the police officer represented in his arrest affidavit that he refused standardized field sobriety tests, which is potentially resulting in additional confusion today. Officers put him in the back of the car, and once his history was realized, they got a warrant based on intentional misrepresentations, disengaged the body cams, and it's an extremely unique circumstance in the sense that they held him for several hours. They allegedly took blood. There's no video of it for 5.5 hours. And the police officer who took the blood left the police department with the blood in on his person for several hours prior to returning back to the station. None of which, very little of which is actually on camera. For all of these reasons and more, the judge in this case, again, deferred ruling on the probation violation and suppressed all evidence in the case. We quoted the judge in our letter to say that he had thought about, why do I need to wait, even though the defendant has a previous conviction for the type of conviction he has. The state took a writ to the Third Circuit. The appeals court reversed in part, but did not address the handling of the blood and remanded for the court to consider some cases on the search warrant issue. And we are currently drafting a writ of certiorari to the Supreme Court. The judge has continued the probation violation hearing pending our filing of the writ with the Supreme Court. The benefit of this info is that the judge who hasn't violated the defendant's probation and has suppressed the evidence has heard significant live testimony in the case. Additionally, I would point out the defendant's fourth offense charge is not actually going to be a fourth offense charge, but a third offense charge. And this makes up part of the information that we would like to send the board should it not allow us to defer. Having said all of this, I believe it is extremely likely that Mr. Natali committed no new criminal activity, and he would like the opportunity to continue defending himself before suffering additional ordered jail time, hence our request for deferment. If we are able to resolve the criminal case without a conviction, but my client's parole is revoked today or before the criminal case is resolved, I think such is unnecessary at this stage with his already being incarcerated. If his criminal case results in a conviction, his probation will be automatically revoked, resulting in him serving his original suspended time on the underlying conviction, together with additional time on the new conviction, which will exceed his parole time in this case as well. Accordingly, that is why we're asking that the board in its ruling defer its ruling on parole. In the alternative, recess the hearing, leave the record open, and allow us to supplement the record and defer its decision or withhold its decision until disposition of the criminal charge. And finally, as a third alternative, we ask that the defendant be committed to a community rehabilitation center or substance abuse treatment program pursuant to the board's policy outlined in Title 22. The sanctuary exists. It's not far from our current location. In the event my client is sent to treatment for up to a year, This would give time for his criminal matter to resolve, would provide him with necessary tools all of us need to survive and be successful post-incarceration. And if ultimately convicted, because he is a young man, his receiving treatment would harm no one and reduce any risk to the public in the future, while also not unnecessarily punishing the defendant prior to his criminal case being resolved in the court system. If convicted, he will serve additional time beyond that required for the parole violation because of his probation and required suspended time. So treatment here with the chance to return to supervision does not harm anyone, in my opinion, and is, in my humble opinion, a responsible alternative should deferment or withholding the disposition not be allowed. I want to thank his brother, Ryan, for appearing in his support. His mom and dad are also standing close by, as well as his grandpa. That's all I have at this time. And I appreciate the opportunity to be heard, Ms. Ledoux, and the other members of the board, Mr. Prater and Mr. Tillis.
Well, thank you, Mr. Adams. You're prepared as usual. I would like to ask my colleagues if they would like to ask some questions at this point.
Do not.
Okay, Mr. Tillis?
I'm good.
Okay. Let me just reiterate a few of the facts of the case that I believe should be considered in our decision and will be considered in my decision. Mr. Natali was sentenced to a 10-year sentence, and which was the result of a plea bargain, and served 2 years, 8 months on that sentence. That was a significant break for a vehicular homicide case, in my experience. The contentions of the mishandling of evidence is not something that, as a panel, we take into consideration in terms of the legality of it, because we have a reasonable expectation that the preponderance of evidence leads us to believe that a violation has occurred. Based on the police reports that we have before us, and trust me, I've read them in depth. I've listened to the conversations. I've done due diligence on this case. Mr. Natali had a blood alcohol level of 0.167 that is attached to this case. And so, in my mind, those are, I've read all the police reports, and you have the right and will and have challenged those. However, today, that is what our decision must be made upon. So without my colleagues having any other statements, I would ask Mr. Natali, would you please give us a statement in your own words about this situation?
Yes, so and I can tell you, as an officer of, as an attorney and officer of the court, my client wants nothing more than to speak about, to be able to speak freely, just in general. The issue that we have is that he's currently being prosecuted by a prosecutor, and these meetings are recorded and they're broadcasted online and they're available to the public. And so my fear is that asking him to specifically comment on the allegations that he's facing that are right now in the court system and may very well be pending trial at some point, or well, are pending trial, but may very well be pending trial, could cause him, if he stumbles or says something, because you can be completely innocent, but you can still incriminate yourself if people believe you've committed a crime. And so I hate to do that, because I know that's not what you guys like to hear, because I get it, it's separate, but that is unfortunately my job. And that's just another reason that we're asking for a deferral, and that the record remain open. And that, while we're also pointing out that since he's already incarcerated, that to do so would not put anybody at risk or jeopardize anyone's rights, regardless of how informal those rights are, whether in front of the parole board and its decision-making process or in the criminal court system. I hope you respect that answer. That's the best I can do.
Absolutely. That is your role in this hearing and is respected. If the panel has nothing further, I appreciate your position, Mr. Adams, Mr. Johnson, and Mr. Natali. But today, based on the evidence that we have before us and the way that we review our cases, and my vote is going to be to revoke parole. And he's, parole is a gift, as you both are very well aware of. And he did have a 10-year sentence, and my vote is to revoke. Thank you.
Mr. Prater?
With that, I think there is a preponderance of evidence that this occurred. And I think for the protection of the public and Mr. Natali, that I think the best place for him right now is to have his parole revoked, that he be placed in and get some long-term substance abuse at a DOC facility mandated, and that he should not be released until that's completed. That's my vote, revoke.
And I also concur with my colleagues. So today your request has been denied at 9:15. Good morning. My name is Chuck Tillis. We're at Ouachita Parish.
Yes, sir.
My colleagues this morning are Ms. Jerry Ledoux and Mr. Steve Prater. Would you state your name and DLC number for the record, please?
Oh, my name is Quincy Lavelle Hampton. DOC number is 542196.
Is anyone in with you? Staff?
Oh, yes, sir.
Yes, sir. Good morning, Deputy Marshall.
Thank you, sir. Mr. Hamilton,
Sir.
I'll be handling your case today,
Yes, sir.
and there's some rule violations that we're going to go over. You can answer guilty or not guilty or with a statement.
Yes, sir.
We have rule violation 4. Hampton was charged with aggravated battery by the Ouachita Parish deputy on 12/15/23. According to the affidavit, Hampton was involved in an altercation with a weapon identified as a shank. Hampton was arrested on December 15, 2023 for aggravated battery. The 4th JDC District Attorney's Office later also billed Hampton with aggravated battery. On March 25th, 2024, Hampton pled not guilty to the charges of aggravated battery. He had a court date of September 23rd, 2025 for the pending charges. A record check as of 9/29/25 shows this case is still pending. How do you plead? Guilty, not guilty, or guilty with a statement?
I plead not guilty with a statement.
Okay, let's talk about it.
All right. On above date of time, I got my I barely can read, but I got 2 write-ups right here to on one of the write-ups, it's saying different from the other write-up to where I was rebooked for, I'm not gonna lie, I'm just be honest, because I just did like 8 years and some change for the state to where when I was arrested, you know what I'm saying, for having outstanding warrants that DOC let me out of prison with outstanding warrants over my head. I got paperwork and everything on me to where I never did have a chance on parole for once. But when I got locked up and came to jail, it wasn't nothing but a simple fight because all us was cleared by OCC medical staff to where the other offender did not have to go out the gate, get no medical attention, no nothing. Only thing we was done, all offenders was seen by OCC medical staff and went back to other dorms. We was separated from each other. And all of a sudden I was rebooked on an aggravated battery. And they had 2 other guys that was indicated in the fight to where it was a group fight to where they saying that I made a stabbing motion, but it wasn't a stabbing motion that I made because I threw my hand up because I know how to fight. That's all it was. I know how to fight. And if you look at the cameras, if you can see the footage that the guy approached me first, to the only thing I was doing is just defending myself, trying to fight it off, trying to fight him off me. That's all it was. To all right, we got two accident reports to where it's not adding up. To where I talked to my lawyer, and my lawyer said when I go back to court that they can't even get in touch with the victim or none of that. He's not coming to court, no, none of that. To where I was just saying to where I never did have a chance to be on parole. I got out of jail and I came in contact with police officers as I was at a female house that I met when I got out of prison. And you know, we did our thing, no disrespect or nothing. And she said that this what she said when she called a police officer, that I pushed her outside the residence, but the judge dismissed all the charges on me because the police officer said they had buku altercations on this female. I'm not knowing the female. I'm just not coming home. All I know, we just clicked up made out, and that was it. I never did put my hands on the woman, no, none of that. So, all right. The only thing I was just asking the board was, can, I get a chance to be on parole because I had outstanding warrants over my head coming from out of prison, and I got proof of everything right here.
Okay, I missed something I wanted. Did you get a questionnaire?
Sir,
Do you have a questionnaire there in front of you?
a question? What you mean by a question? Like
Questionnaire.
oh, paper? Paper.
You want to put it up?
Sir? Oh,
You-
yes, sir. I see it.
See that? Did you sign that?
Sir?
Did you sign that?
Yes, sir.
You understand it?
I really didn't, because I was trying to ask my parole officer, because I never did saw my parole officer. I only saw my parole officer when I came to jail. So I was asking him like, what do this mean and things like that. To where he was saying that it was I filled out for the first person I saw to defer my parole until to this case of me being rebooked on an aggravated battery. You know what I'm saying? I asked him.
Okay. All right, you signed that?
Yes, sir.
You feel that you need an attorney?
Yes, sir.
You want to hire one? You're not entitled for us to give you an attorney. You want to hire one?
Yes, sir.
Okay, where do we go from here? Say what? You want a continuance?
I don't know what that mean, like what the continuance mean, like, well, do we?
You don't have an attorney, you're gonna need time to get an attorney.
Oh, yes, sir. Yes, sir.
Say it again. Miss Jerry,
So, he can read and write and he understands the allegations against him?
he said he couldn't read.
He can read and write. And do you understand the violations against you?
I don't understand the violation because when he read it to me himself. I barely can read, so he read it to me himself.
I defer to the chair.
Okay. So you would like to have a continuance to get you an attorney?
Yes, sir.
All right, at this time, I'm gonna call for an executive session. Can I get a second?
I'll second.
Okay, we're gonna,
Tillis,
yes,
Prayer. Prayer.
What they say?
Yes.
Adu.
Yes.
this time we're gonna stop for an executive session. We'll be back shortly.
Okay, is anybody in the executive session?
Okay, we're back in session. It's 9:36. Can I get a motion, make a motion that we get back into our regular session? Can I get a
I'll
second?
make a motion.
And second.
Okay. Mr. Hampton,
Yes, sir.
decided to move on with this case. You've had plenty of time to, you read your questionnaire that you had and you signed the papers, so we're gonna move on. And your case was assigned to me. So you say you're pleading, not guilty to the charge of number 4, rule number 4.
What number 4? Yes, sir. I'm pleading not guilty to that charge.
Okay, it's recorded. Also violation number 5, according to the affidavit on the above listed charges, Hampton used a shank as a weapon in this dangerous, deadly manner. How do you plead?
Not guilty.
Not guilty? With a
Yes, sir.
statement?
I plead not guilty with a statement.
Okay, what's your statement?
All right. All us was removed from a cell, and all of a sudden you find a shank on my bed to where you never got no shank off of me or none of that. But you got a shank when I was removed from out the cell with 9 other inmates in the cell.
Okay. Were you fighting?
I'm not gonna lie to you. I was protecting myself because the person who came toward me was trying to swing on me. So all I was doing was just to protect myself. Because in jail, you got to protect yourself. You ain't gonna let nobody hurt you.
Okay, that's good. Mr. Prater or Ms. Ledoux, do any of you have any questions?
No, it's important, Mr. Hampton, you realize as a third felony offender, you knew when you were coming out of prison that you had the detainer on you.
I went signed up for parole and everything. Didn't nobody tell me I had no warrants. I did everything the parole officer told me to do. I got out of prison. I came and signed up. I never ran. And I never did have a chance to be on parole because I had outstanding warrants still depending on me.
That's right.
And when I went up there, I told them, I asked my parole when I was signing up. I asked them, I was like, is I'm clear? They said I was clear. So it wasn't on me if I still had outstanding warrants that was when I was released from a prison. I didn't know. I thought I was clear of everything.
Okay. Okay. Okay.
Yes, ma'am.
All right. Thank you.
Yes, ma'am.
Steve?
Yes, sir. You understand and should understand. You can put all that out of your mind about when you were arrested, whether you had detainers, whether you got out or not. The point is, and why we're here, is that while on parole, you committed a crime and you possessed a dangerous weapon. And that's all we're here to decide about. And so that's what I'll be making my decision on, if there was a preponderance of evidence that you committed a crime or possessed a dangerous weapon. And so that's all I have to say.
Is everyone prepared to vote?
Yes.
Okay, Mr. Hampton, I have your case today and my vote today is going to be to revoke on rule number 4 and number 5. Mr. Prater?
I concur with you, Mr. Tillis.
Ms. Ledoux?
I vote to revoke. I find him guilty of violating rule number 4 and 5.
Mr. Hampton, you've been denied today, and this concludes our with you at CALCASIEU at 9:40. Washita, I'm sorry, at Washita. Thank you. Good morning. My name is, can you hear me?
Yes, sir.
My name is Chuck Tillis. I'm chairing this committee this morning. My colleagues are Mr. Steve Prater and Ms. Jerry Ledoux. Our remote location is at Concordia and Parish for revocation. Would you state your name and DOC number for the record, please?
KEON LEONARD, 757-671.
Do you have a questionnaire in front of you?
No, sir. No, sir.
You didn't receive a questionnaire?
No, sir.
Can you put it up, please? Hold on just a second. Okay, do you see that, Keon?
Yes, sir. I see that.
You signed it?
Yes, sir.
Okay, thank you. Okay, is there anyone in there with you this morning, staff?
Melanie Book with Concordia Corrections, and Mr. William Yarborough is his attorney present on compound.
Okay, thank you so much. Mr. Leonard, I'll be handling your case today. We have
Yes,
some
sir.
rule violations that you did, and I'm going to read them to you, and you can answer with guilty, not guilty, or with a statement.
Yes, sir.
You were arrested on 7/8/2025 by the Faraday Police Department and charged with cyber building on 8/20/2025 under dockets CON 25-1. The charges was dismissed. How do you plead?
Not guilty.
With a statement? You have a statement, you're pleading not guilty. Why are you pleading not guilty? What's your statement?
I don't understand what he's saying.
You couldn't hear him?
I said, I don't understand what he's saying.
Okay. I read those charges and asked you for a statement, guilty or not guilty. You said not guilty. I'm asking you if you want to make a statement.
No, sir.
Okay. Rule number 4, you were also served with protection order that was signed by Judge Kathy Johnson on 7/2/2025, which shows domestic actions. You were served with an order at the time of your arrest. How do you plead? Guilty or not guilty?
Not guilty.
Not guilty.
Sir, this is William Yarborough, his attorney, and I have court minutes where the charges for cyberbullying were not accepted for prosecution by the district attorney.
Okay, you're his attorney?
Yes, sir.
Okay. I'm gonna let his girlfriend speak and then we'll get back with you. Is that okay?
Yes, sir.
Okay, thank you, sir. You have his girlfriend on Zoom, which is Jasmine Skinner. Ms. Skinner, would you like to make a statement on behalf of Mr. Leonard?
Yes, sir. There were restraining orders that I did, and they were just misunderstandings. I didn't go to court for neither one of them to get them to keep going, so they both were dismissed against him. And I did get charged for those, so I had to make a payment for those. So I just wanted to make a statement about that.
Okay, thank you so much. Mr. Yarborough, Mr. William, I'm sorry, I have a form now that he has an attorney, so go ahead. You want to make your case, please?
All I can say is that Mr. Leonard was magistrated on August 20th, 2025. And then on Thursday, July 10th, 2025, the district attorney did not accept the charges for prosecution.
Okay. Mr. Prater or Ms. Ledoux, you have any questions you want to ask?
I would like to ask one question. In the parole officer's notes, he records that you were picked up or stopped on the street, was an arrest, but that you were high on drugs and you were drug tested and found positive. And you were referred to Celebrate Recovery at a church there in town. Did you ever go to that program?
I never took a drug test before with my parole officer. That's not true. I never had a drug test took me with my parole officer.
No, it was by your own admission. You told him.
You did it. You was
You said you would be high. You said you were high at that time.
No, ma'am, Ms. Gerald LeBlanc. That's not true.
Okay. That's all.
Mr. Prater?
I'll read this to you. He approached the vehicle and I could smell the odor of THC. I asked the offender if he had been smoking and he said yes. He was placed in cuffs and we drove him back to his house. He stated that he did not think he needed treatment at this time. I asked the offender why he missed intake. He said he didn't have a ride. The offender was instructed to report to Concordia Corrections for intake and also to attend Celebrate Recovery. And the offender stated that he understood. I'm just reading what the parole officer who supervised you said.
Yes, ma'am, that's not true. That's crazy.
What is true? Then tell us what is true.
None of that what my parole officer said. Sure, I don't know nothing about that.
Mr. Williams, do you have anything to add to that?
Excuse me, sir. You have to excuse me. Dr. Fauci's virus killed my hearing. So I can't hear as well as I could before I had the COVID virus.
Oh, okay, okay. Did you want to add anything to this statement that what the parole officer said with his drug test?
I had no information about that, sir.
Okay, okay. Steve, you have any questions?
I'm a bit confused. Did you text those threatening messages to someone?
No, sir.
You didn't even do that.
No, sir.
Who texted them? Because I think that didn't your parole officer or the police have copies of them?
They got somebody showed them some messages that they said was me, but it wasn't me texting them.
Okay. All right. And well, I'm a bit confused because they're pretty sure that it was you. But I think that how long have you been on parole?
Well, almost a year.
Okay, and when did you have when they find the THC in your room? How long had you been on parole then?
Ain't never got THC found in my room before.
The parole officer went to your room and your mom was there and let you search your room, if I'm reading the right offender. KEON Leonard, is that your name?
That's my name. I never had no THC found in my room before, sir.
Well, you approached the vehicle and you could smell the odor of the parole officer could smell the odor of weed. He asked if you'd been smoking. You said yes. You were placed in cuffs and drove back to your house. Let's see. Before that, the agents went to your house, made contact with your mom, who showed them where the offender's bedroom was, and that he observed an empty canister containing THC residue.
No, sir.
None of that happened, huh?
I don't know nothing about that. That's what I'm saying. This is my first time hearing it.
Well, it's written in the record, and the record was typed up in September 24.
Oh, sir. Great.
I think you have a memory problems or something. Okay, that's all I got.
Okay. Is the panel ready to vote?
Yes, sir, I am.
Ms. Ledoux? Mr. Leonard? I'm trying your case, or not trying your case, but I'm handling your case, and we're here to the rule violations that are against you. That's what we're here to vote on. And my vote today is going to be to revoke revoke for rule number 4, number 4A. Ms. Ledoux?
Yes, reading the violations, whether the charges were dismissed or not, I do believe there's evidence that there's a violation of his conditions of parole.
Mr. Prater?
Concur. I believe that there are preponderance of evidence that these violations did occur. Revoke.
Mr. Leonard, your case has been denied, revoked today, and this ends our meeting here.
So can I ask y'all something?
At
When is my
98.
okay.
Hello? Yes.
Good morning. Mr. Michael, how are you?
All right.
My name is Chuck Tillis. My colleagues are Ms. Jerry Ledoux and Mr. Steve Prater. I'm going to read some information into the, is there a staff there? Well, we've already met the staff.
Melanie Book.
Hey, Ms. Brooks, how are you?
I'm good.
Good. Get this. What's his name? Michael? Mr. Michael, I'm going to read some information into the record. And would you tell me if it's correct? You're a first-class offender. Offense was indecent behavior with a juvenile, 2 counts. You were sentenced to June 18, 2015, sentenced to 17 years hard labor. You're not eligible for good time. Your full term date is July 29th, 2031. Is this correct?
Yeah.
Okay, Ms. Ledoux will be handling your case, but I'm going to let her go ahead and ask you some questions first. And we don't have anyone on your behalf today. Ms. Ledoux, you want to handle it?
Sure. Thank you very much, Chair. Mr. Cormier,
Yeah.
I'm going to ask you, why are you in prison, and why do you think that we should offer you an earlier release today?
Well, I realized my mistakes I did, and I learned my lesson to stay out of trouble. Because jail ain't nothing but trouble.
So, mistakes. You made a mistake. What kind of mistake did you make?
Improper behavior with a juvenile.
Okay. Were the victims your biological grandchildren?
One of them.
Okay. And what were the ages of the children involved?
7 and 6.
Boys or girls?
Huh?
Were they boys or girls?
Girls.
Okay. And you were about 56 at the time you did this?
Yes.
Mhm. Since you've been incarcerated, have you been anywhere that you could take sex offender treatment?
No, I've been to Christian classes and stuff like that.
Have you taken the pre-release class?
I don't know what that is.
And I doubt you've taken it. What about, have you taken, literacy, GED education classes?
No, it's hard for me to learn. Understand? I can't read and write.
Let's see. Okay. Gotcha. Um, Today, we do have two people who would like to speak in opposition of your release. And at this time, I would like to call on first Miss Melissa Cody. If you would like to speak, please.
Yes, ma'am. I do not believe that he deserves the right to be out. I think he deserves to be 6 feet under the prison for all the indecencies that he has taken from my daughter. He's taken things from her that she cannot have back. It has put a toll on her progression in life. And it's not fair to her that he gets to roam free or anything on probation or on parole. To me, he lost those rights when he decided to place his hand on my child.
Okay. Thank you very much. I understand your feelings. Miss Boudreaux, would you like to speak at this time?
Sure. So I agree 100% with Melissa about what she said. And it's pretty much the same, with Ava. Uh, she she pretty much doesn't leave her house. She has really bad anxiety issues, so I do agree when I say that he should not be free at all.
Okay. What is your relationship to the offender?
Um, I was his daughter-in-law.
Okay. Okay. Thank you very much. I appreciate your time here. Do either of my colleagues have any questions?
Do not.
I do not.
Mr. Cormier, would you like to make a statement before we vote? I'm prepared, but if you'd like to make a statement.
Well, I can say I'm sorry for what happened. All I can say is I apologize very deeply for what happened.
Okay.
All I can make.
And I appreciate your remorse. Mr. Cormier, based on your lack of programming, and I realize some of that is not your fault, but there are certain things that we need to see, measurements that we need to see you progressing towards, so that we have a comfort level with you being on the streets again prior to your good time, your good time date, or your full-term date in this case, since you don't have full good time. And I do believe that without those classes, I would be concerned about public safety. And you do have opposition and lack of transition plans. So my vote today is to deny your parole.
Mr. Prater?
My vote also is to deny parole, lack of programming, seriousness of crime, victim opposition, law enforcement opposition. Thank you.
And I concur with my colleagues. Today, your request for parole has been denied, Mr. Michael. And we're signing out at 10:13. Good morning. Good morning. Would the staff give us their name, please, for the record?
My name is Lieutenant Jonathan.
Thank you. Thank you for hosting us today. My name is Chuck Tillis. I'm chairing today. My colleagues are Ms. Jerry Ledoux and Mr. Steve Prater.
Good morning. Good morning.
Our remote location is at Riverbend Detention Center.
Yes, sir.
Would you state your name and DOC number for the record, please?
Matthew Lee Gray, 390296.
Okay. Mr. Prater, Mr. Steve Prater has your case today and he'll be handling your case. Would you answer these questions for him, please?
Yes, sir.
Mr. Gray, let's talk about it. Do you have a form in front of you that explains why we're here today? And did you sign this form?
Yes, sir.
And you understand that and you signed it and everything?
Yes, sir.
Okay, good, good. Well, when you get out of jail, you agree to certain conditions that you'll live by.
Yes, sir.
And your parole officer reported to us that you didn't abide by all of these conditions that you're supposed to. And so then it throws it into us to have to decide if you're going to be revoked or not and go back to jail. And I'll read these charges and I'll go over them and let you tell me what you think about them. See if you're guilty or not guilty. I know you've had a preliminary hearing already and you've pled on these, but I want to hear it from your mouth. Okay, and in 8 of 2022, you had a drug screen and you came back positive for amphetamine, THC, methamphetamine, PCP, and cocaine. You were instructed to go to a drug abuse treatment center and you didn't go. Is that true or not?
That's not true. I asked my parole officer to send me to Crowley to the wake. As soon as I came home, my girlfriend had a place for me to stay. When I got there, they didn't have nothing in the house, so people ended up giving us some furniture. She just got the house for us. Now it was a couple things that has been going. In the neighborhood is not a good neighborhood, but it was the only place I had to stay. So with that being said, I had my parole officer come over there, and he's coming to my house, and he asked me a couple of questions, and I told him I didn't like living here because there was a whole lot going on. And I asked him, could I go to the way up in Crowley? It's supposed to be a rehab place and a drug thing.
Mr. Gray,
Yes, sir.
Excuse me, I apologize for interrupting you, but we need to focus on what I'm asking you, and then
Okay.
okay? Did you have a drug screen done?
Yes, sir.
Yes, sir? Did
Yes,
you say?
sir.
And were you positive for these things?
Yes, sir. I admitted to that.
Okay, good. Okay, well, let's move on, and we'll come back and give you a chance to talk some more.
Okay.
Then on 11 of 2022, you were arrested for aggravated arson, and you pled no contest in September of 25 last month, it looks like, and you were given 6 months in jail for negligent arson. Are you guilty of that?
They said no contest. The lawyer told me just plead no contest, and we're gonna give you it's not a felony, it's just a 6 months misdemeanor. We just gonna give you credit for time served.
Okay. All right. And then again in 11/2022, you were tested for drugs and you came back hot for amphetamine, methamphetamine, and THC. Are you guilty of that or not guilty?
I only this parole officer only drug screened me one time. One time since I was home.
Okay.
There's
So
only
you think
one drug screen I took, and I failed it. I admitted and told him that I had used some drugs. Yes, I told him I needed to go to the way. It's nothing but a drug environment out here. I needed to get out and go get me a life somewhere else.
yes. Okay. Well, let's move on now. It says in violation rule 6 that you failed to provide proof of employment or that you had been looking for employment. Are you guilty of that or like?
Understanding what, I just came home and, I didn't have nothing in my house. As I say, she had just got a job working at Sonic. And I was home. I was just home cleaning up and making sure everything was in order until I found a job. She didn't have no car. I don't have no car. So she'll walk to work and it's hard for me to, find a job too. So, and this little town really don't have no jobs in Church Point. So, and without no vehicle, you really have no job. So she had to walk to work to Sonic and
Okay.
I didn't have no job at the time. I just come home.
Okay. Rule number 8 says that you failed to enroll in the Lafayette Day reporting as you were instructed to do. Are you guilty or not guilty?
I'm not guilty of that because I told him he asked me to if I wanted to go to Lafayette. I said, yeah, I'll be a motivational speaker. I said, yes, sir, I would go. I told him I would go.
But did you go?
No, I didn't have no ride. I asked him to call and everything.
Okay.
I don't have no transportation.
Okay. And then number 10 says that you've never made any payments on your parole fees and you owe $2,961. Have you ever made any payments?
I have no, I just came home and it's been a whole lot going on. I haven't had $1 in my pocket, sir.
Yes, sir.
She had a job and she was trying to pay bills and it's just been a whole lot going on. I haven't had $1 in my pocket.
Well, let me ask you something. I mean, tell me what's going on because we want you to be successful, but you're not successful.
Right.
And you were paroled in July of 2021 and you immediately started using drugs and on and on and on. So give me your statement now before we end up making any decisions.
I'm in the wrong place. I'm in the wrong place. There's no jobs out there. I need to be in a city or somewhere where I get to work and I have transportation. I need to make sure I have a job. That's why I need to make sure I have a job. There's no jobs in that town. That town is full of destruction. I can't see myself really doing better in that town. I mean, there's nothing there. There's a population of 6,000, but only jobs for 50 people, 100 people. I mean, there's no jobs and it's just sad. I got to try to give me transportation and go to another town where I can give me a job and get my life together. I'm 47 years old. I don't want to see my life in prison no more.
Have you ever had any drug treatment, substance abuse?
Yes, I did.
What
Yes, I
course?
did.
Tell me.
Sir?
Tell me what courses.
Oh, it was Blue Walters. It was Blue Walters in Richwood.
Did you complete it?
I completed it all. I completed it all, sir.
What year was that?
I want to say in 15 or 14. I completed that.
Well, it doesn't seem to have taken, did it?
Sir?
It doesn't seem to have taught you anything, did it?
I guess, when you get thrown back in that same environment and it's no jobs over there. It's surrounded by it's drug infested environments with no jobs. I mean, it's hard. It's hard.
Yes,
It's
I
hard.
understand that. Okay. Mr. Chairman, I don't think I have any other questions.
Ms. Ledoux, do you have any questions?
Well, I do. I want to clarify something. Mr. Gray.
Yes, ma'am.
Your parole officer may have only tested you once. The second time that you were tested was while you were incarcerated in jail. You tested positive.
I don't even think I ever even took.
That's what the file indicates, is that's when you were tested positive while you were in jail. So
When I was arrested?
it says the parolee was arrested for committing the felony. No. Hey, 2 days later, you were tested positive, 2 days after you were arrested while you were in prison, while you were in jail.
I don't even think I was.
So, Mr. Gray, what you're talking about is a lot of decisions. Yes, the town may not have a lot of jobs. Not everybody who lives in a small town without a job smokes or does drugs. See, you're making some excuses. And you need to take some responsibility for your choices, okay? So I just want to point that out. Thank you.
Okay.
Mhm.
Okay, is the panel ready to vote?
Yes, sir, I am.
Mr. Prater?
My vote is to revoke your parole because of violations of rule number 4. 3 different sections of number 4, number 6, number 8, and number 10.
Ms. Ledoux?
I concur with my colleague and vote to revoke on the same premise.
Mr. Matthews, I also concur with my colleagues. Perhaps while you're incarcerated, maybe you'll try and get some drug classes to better yourself. So you have been revoked today, and this will end our meeting here at Riverbend.
Okay, with me being revoked, I get credit, all credit for time served.
Good morning, Mr. Morton. How are you? Good morning. You have your cell phone mute. Can you unmute, please?
Good morning, sir.
Good morning. My name is Chuck Tillis. My colleagues are Ms. Jerry Ledoux and Mr. Steve Prater. Would you state your name and DOC number for the record, please?
Abel Agapito-Cabrera, 786380.
Repeat that again, your DOC number?
786380.
Is that correct? No. Are you Michael Morton?
No, sir. My name is Abel Agapito-Cabrera. ABEL.
Okay. Okay. Would the officer come back in, please? Lieutenant?
Yes, sir.
We need Mr. Michael Morton.
Michael Martin.
Yes, sir.
So you don't need him.
No, sir.
Okay, come on. Stand up.
Good morning. My name is Chuck Tillis. Are they on mute? Can you hear me? No, we can't hear you. Still on mute.
Yes, I can.
Okay, thank you so much. My name is Chuck Tillis. I'm chairing today. My colleagues are Ms. Jerry Ledoux and Mr. Steve Prater. We're at LA Correction Institute. Could you state your name and DLC number for the record, please? Ms. KAITLYN?
I'm sorry. This is her grandmother.
Okay, all right. Ms. KAITLYN, can you all on mute? You're not on mute? Can you hear us? We can't hear you. I can't hear you.
Can you hear us now?
Loud and clear.
Caitlin Napier, 00796-135.
Okay. You have someone, your grandmother, that's going to speak on your behalf this morning?
Yes, sir.
Give me 1 second, I got lost. Okay, Ms. Caitlin, I'm gonna read some things into the record and you tell me if you agree with them or if they're true.
Yes, sir.
Your first class, you offender first class.
Yes, sir.
Your offense was theft, distribution of drugs, methamphetamines, distribution of methamphetamine, Schedule 2. You were sentenced on February 2025. Your sentence was 2 years at LA to serve 7 years. Also, you were sentenced 4 years. Is that correct? At LA for 4 years, and 3 years were suspended. Your parole date is February 16, 2026. Your good time date is July 9, 2026. Your full term date is February 16, 2029. Is that correct?
Yes, sir.
Warden, would you guys introduce yourselves for the record, please?
Assistant Warden LaShonda Burks.
Tara P. ARDC Manager. Afton Gaddy, ARDC Supervisor.
Thank you so much. Ms. Caitlin, would you tell us what got you incarcerated and why we should have a favorable?
I didn't hear the second. I'm sorry, I didn't hear the second part.
Tell us why you got incarcerated and why you think we should rule favorably for you today.
I have got incarcerated behind being an addict. Becoming an addict made me lose everything. So when you lose everything, you try to gain it in a wrong way. I take full responsibility for my actions. I know I went down the wrong path, but if I'm granted parole today, I'm going to be going home to my grandmother. I'll be having a stable job. I'll be a better person, not for myself, but for my daughter and my family. I'll be wanting to do outpatient care and parenting classes if I am able to get released for parole.
Okay, how long have you been incarcerated?
Since February 20th.
Of this year?
Yes, sir.
So what have you been doing about or for your drug addiction?
Well, I've been taking Duvo classes in Tallulah. They stopped doing our classes, so I wasn't able to get into any classes. So, but whenever I get released, I'll be going to an outpatient care.
I see. Warden, do you all have anything that you can help us with or make a comment about her?
Yes, well, she just transferred from Louisiana Transitional Center for Women to LCIW last week. She has no disciplinary reports in her record. She has a low risk need assessment score. She's a medium custody inmate, and she plans to live with her mother if granted parole. That concludes my comments.
Do y'all have any classes there that you could offer her?
Yes, we do.
You do? You plan to enroll her in some?
Yes.
Okay, thank you so much. Appreciate you guys hosting us today. I guess we'll hear from my grandmother now. Miss Karen,
Yes,
how are you this morning?
I'm fine, thank you.
Good. What would you like to tell us on your daughter's behalf?
Right. Well, Caitlin is my granddaughter, but we raised her since she was an infant. And she's always just wanted the love from her mother. And when she graduated from school, she got her CNA certificate and she went to phlebotomy classes and she started living with her. And just from what I understand, her biological mom was not a good influence. She was into drugs, selling also, and KAITLYN went down the wrong path with her. I can tell when I have talked to her since she's been incarcerated, her voice has changed, her attitude's changed. She has set goals for her life when she gets out because she's lost everything when she was incarcerated. And I do think that she wants to be a better person, and she will be a better person. I know that.
Thank you so much for your comment. We appreciate it.
Yes, sir. Thank you for letting me have the opportunity.
Ms. KAITLYN, your case was assigned to me. I read through your file. I see where you were working to supply your habits, or what? Stealing where you were working at?
Yes, that's when I started my addiction. Whenever I started working, and like I commented, you get to the point where you lose everything. So when you lose everything, you'll do anything to get the drugs you need, and it led me to theft.
How old were you when you started using drugs?
Using the drug that got me in here, it happened in 2021. So I was about 25.
When you started using drugs?
Using this particular drug, yes, sir.
Okay, were there any other drugs that you were using?
I was on just methamphetamine and Xanax.
Okay. So what's your goal? What do you plan to do to try to correct your problem with your drug?
I want to go to outpatient and continue to learn more about it. Stay away from the people that I were around. Start working, being a better mother, staying away from people that aren't good for me.
You're saying outpatient. What about while you're incarcerated?
Yes, sir. Substance abuse, if they are willing to give it to me, substance abuse counseling.
Okay. Any of my colleagues have any questions? Ms. Ledoux?
No, I did want to ask the assistant warden. She has a high needs score. I know it's a low risk score, but a high needs score. Will y'all be doing a mental health evaluation with treatment?
Yes, and she has been referred for a psych appointment already.
Okay.
And as far as the classes, she's backlogged for them as well.
So you do have her lined up for substance abuse and all of that to get in immediately?
Yes, and a psych referral as well.
Okay, great. Thank you.
Mr. Prater?
So if I'm reading these dates right, you're not eligible for parole until February of next year. Is that correct?
Yeah. Yes.
Okay, and then your good time date is in July, 4 months later.
Yes.
So we're talking about 4 months, correct?
Yes,
Is
sir.
all you're wanting to get out 4 months early. You're wanting to get out in February instead of July of next year, correct?
Yes, sir.
Okay. That I just wanted to make sure. It's kind of confusing, but anyway, that's all. I'm prepared to vote.
Okay. Ms. KAITLYN, I am handling your case, and I'm also prepared to vote. I think that I'm going to have to deny you today. I think you need to get some more treatment, some more classes, and it seems like I wish that you would do it as soon as possible, and I hope you continue it upon your release. So my vote today is to deny. Ms. Ledoux?
Yes, I concur. My vote is to deny based on the lack of programming, limited time that she's been in, and has not addressed some of the needs she has.
Mr. Prater?
Concur to deny, and I'd like to see her get some, as much as long-term as she can get between now and when she's released, but I definitely think she needs to spend the rest of her time in jail.
Okay, Ms. Caitlin, your request today has been denied. And this will conclude our stay at 11 o'clock today at the Louisiana Corrections. Thank you.
All right. I'm not really
Good morning. I think you're on mute. You might be on mute. We can't hear you. Is someone in there with you? You're on mute. Lieutenant. Tell him I'm mute. Are you on mute?
My name is Lieutenant Jonathan, sir.
Okay, thank you so much. My name is Chuck Tillis, chairing today. My colleagues are Jerry Ledoux and Mr. Steve Prater. Would you state your name and DOC number for the record, please?
Michael Martin, DOC number 486696.
Okay, Mr. Morton, do you have a questionnaire with you?
Sir?
You have a questionnaire in front of you?
Questionnaire? What's that, sir?
No.
I guess not.
Do we have one? Just a second, we're gonna pull it up. You got it?
I know that we confirmed it in July, yes,
Hey, Mr. Morton. Mr. Morton,
Yes, sir.
can you see that questionnaire?
Yes, sir.
Sign that?
Yes, sir.
Okay, thank you. All right. Mr. Prater has your case today and he'll be handling it. Would you answer his questions, please?
Yes, sir.
Mr. Martin,
Yes,
you
sir,
are,
Mr. Prater.
you're familiar with this board because we ruled on you back in July, I think it was. We gave you a tremendous break and sent you to a work release facility in lieu of revocation where you could make some money and prove that you're going to do good. You remember that?
Yes, sir.
Okay, and then about 2 months after you got there, you were found to be in possession of some synthetic marijuana. And that's what you're charged with today. We're trying to decide what to do with you. Is that correct? Were you in possession of synthetic marijuana?
No, sir.
Did they tell you were, and that's why you were removed from the program?
No, they did a urinalysis on me and I passed the drug test and he told me they was gonna ship me.
Well, you understand, you've got to possess something outside your body before it can get inside your body. And all that drug test on your body showed was that it wasn't inside your body yet, but in your possession, outside your body or in your hand was this marijuana cigarette, synthetic marijuana cigarette. You remember any of that?
I was giving a guy a cigarette when the guy come up on me and took my pack, and the other guy was sitting on my bed. He picked the cigarette up.
So that's your story and you're sticking with it.
Yes, sir.
Okay, so you didn't know there was marijuana in that cigarette that you were passing from one person to the other.
No, I never had none, Mr. Prater.
Okay. Well, evidently they thought that you did because it was enough to where they could ship you out of there, kick you out of the work release program. That's all the questions that I have, Ms. Ledoux.
I'm prepared to vote.
Okay, Mr. Prater, are you prepared?
Yes, sir, I'm prepared. I think that you did have the marijuana cigarette in the, and I think that you were given a good chance and you blew it. Several times in life, you're making bad decisions. This was just another one, and we gave you a break, and it kind of makes us look bad because we caused the state a lot of money transferring you to one place and give you a shot, and then you immediately violate it. So my vote is to deny or to revoke because of condition number 4.
Ms. Ledoux,
My vote is to revoke.
and I concur with my colleagues. Today you've been revoked, and this concludes our business today at Riverbend. It's 11:11. Thank you. Good morning, Mr. Williams. You're on mute. I believe you're on mute.
Can you hear me now?
I can hear you now.
Okay. All right.
Is there someone in there with you?
No, sir, it's just me.
Okay, my name is Chuck Tillis. I'm chairing today, and Miss Jerry Ledoux is my colleague, and Mr. Steve Prater.
Yes, sir.
Do you have give us your name and DOC number, please?
Matthew Williams, DOC number 480-215.
Okay. Do you have a questionnaire with you?
No, sir.
You don't have it? We're going to put it up on the screen in just a second. Okay.
I see it.
Did you sign that?
Yes, sir.
You understand it?
Yes, sir.
Thank you so much. Okay. Ms. Ledoux will be handling your case today. Would you answer her questions, please?
Yes, sir.
Good morning, Mr. Williams.
Good morning.
I'm going to be reading some rule violations to you, and I'm going to need you to enter a plea of guilty, guilty with a statement, or not guilty.
Before we begin, can I say something, please? The main reason I want to come to parole board, it's not the fact to try to dispute all of the technical violations. What I'm trying to dispute is I'm no longer serving time on an aggravated sentence, so I'm eligible for a tech. I was sentenced to 5 years aggravated flight, ran concurrent with 8. 5 years elapsed March of 2025. I only had 3 years left on parole in a non-aggravated sentence. I'm no longer serving time on RS 14.
Okay, while we're talking, I'm sure someone could be checking on that.
Yes,
Okay?
ma'am.
Okay, first of all, I'm going to read violation number 3, in that Williams has continued to change addresses since his release on good time parole. His first warrant was requested 3/18/25, but was recalled because you reported to the Amite district and then gave a new address in Covington. On 8/4/25, a second warrant was requested for absconding from the Covington district because they were unable to verify your address and your phone was no longer working and none of the collateral contacts knew how to reach you. You were picked up by Bogalusa Police Department on 8/15/2025 and booked on the outstanding warrant. How do you plead?
That statement is not all the way correct, and after I reported to her after Covington, I rode a bike all the way to Amite. I was staying in Bogalusa, and she recalled the warrant then. This is after the Covington thing, so how would I plead that? Because I was not trying to run. I was homeless. I don't, because I did try to report after Covington. Matter of fact, she contacted me after that and said I had a new parole officer, Aaron something, out of Washington Parish. I called him and left a message and never got a response back, which it's hard to get in touch with me because I'm homeless. I have no phone. It was rough on me. It was rough.
So the whole point of having the reporting requirement is so that we can supervise you.
Yes, ma'am.
So were you able to be supervised?
No, ma'am.
Okay.
No, ma'am.
That's that's the gist of it, is we're trying to be able to supervise you.
Yes, ma'am.
Okay. On number 4, 12/17/2024, you admitted to using marijuana and cocaine, and then you did test positive on Christmas, and you were drug screened 6/4/25, and you again tested positive. And how do you plead on that?
Guilty.
Okay. Number 6 says that you did not provide documentation that you were employed, they did contact Rome's Recycling and that you had not been working there for over a month when they contacted them in August.
That I lost my job. Yes, ma'am. I couldn't get back and forth to work. Yes, ma'am.
Number 9, again, relates to the homeless issue. You had no place for them to check, so that your residence and employment contacts could not be checked because you didn't have a place.
Yes, ma'am. That's true.
And 10 is the monetary deficit, $567.
Yes, ma'am. That's true too.
Mr. Williams, I just want to ask, I could do the math if I looked, but how old are you?
39.
39. Have you been homeless most of your life?
Oh, ma'am, this is the first time I've ever been homeless. This is the first time my family's fed up with the jail time. Since I was 17, this is the first time I've ever been out that long without catching new charges. I was really, really trying. Like my record will reflect, I don't stay on the street longer than a year without catching a new charge. But I was really, really trying to stay out of prison, like to the point where she told me, you know, she was putting a warrant, and I still rode a bike from Bogalusa to A-Meet to, you know what I'm saying? I really was trying.
I read all of your agents' narratives.
Yes, ma'am.
On your own admission, you were homeless and strung out on drugs.
I was, yes, ma'am.
The most secure place for you to get some help right now is in prison. You need to address your substance abuse issue. I mean,
prison's not. I need, if possible, I need to go to rehab on the street because prison's not doing it. I'm a 7th offender, and prison just there's more drugs in prison than there is anywhere. I've seen more drugs in prison than I did on street homeless.
Okay. Have you been to a long-term substance abuse program?
No, ma'am.
Okay. Okay. So you'd be willing to go to a long-term?
I'd be willing to go. Yes, ma'am. I'd be willing to go. My mom, listen, my mom's about to die on me. I'm going to do anything to be out there with my mom before she dies, man. My mom, this is no lie. My mom, they had her on chemo. They had to stop the chemo. She's got liver cancer. It's a rare cancer. They had to stop the chemo because it's not affecting it. She got a spot on her lungs now. My mom's 76, you know, which I'm not asking, I'm not trying to make nobody feel sorry for me or anything, but like, I would be willing to do anything so I can be there for her.
I know, but the only place that I'm secure in sending you to rehab is in the DOC custody. So do my colleagues have any questions?
No questions.
I have none.
Okay. Are y'all prepared to vote? I'm ready to vote.
I'm
Yes.
prepared to vote.
Okay, so Mr. Williams. I'm prepared to give you a really big break. The reason I'm going to vote in lieu of revocation to send you to a long-term DOC substance abuse program. And the reason that I'm doing this is because you don't have any crimes of violence against anyone. You didn't have any charges. You have a drug problem, and you have to address the drug problem, or you're not going to be safe on the streets. You're not going to be safe. Public's not going to be safe. So my vote today is to send you to a long-term substance abuse program within DOC in lieu of revocation.
Mr. Prater?
Wow. I'm really concerned, but I agree with everything Ms. Ledoux said. Is there any kind of stipulations we can put on what we say a long-term? Ms. Ledoux, you're more familiar with that than I am. Do we need to be more specific, or?
We're not able to stipulate which program they go to. So it would be at the purview of the Department of Corrections. Also, after release, we can stipulate that Mr. Williams have in follow-up care where you have to go to AA&A on the streets, and also elevated drug screens.
Okay. I concur with what my colleague has voted in lieu of.
Okay, I want to make a correction, small corrections. We at the Washington Parish Jail. I wanted to get that on the record. And also my vote is to concur with my colleagues. This time you've been denied. Say not denied, but in view of revocation. Yeah.
We're gonna take you to a long-term system.
And you'll be hopefully sent to a long-term treatment center. Okay? And this concludes us at the Washington Parish Jail. It's 11:32. Thank you.
Thank you.